and thank you all for joining us. My name is Jeanette Gabriel, and I'm the director of the Schwab Center for Israel and Jewish Studies, and also a faculty member in religious studies at the University of Nebraska, Omaha. On behalf of the center, I want to welcome all of you to the 2021 Sokolof Lecture, an annual endowed lectureship in honor of Ruth and Phil Sokolof. This event, organized by the Schwab Center for Israel and Jewish Studies at UNO, aims to bring speakers of national and international prominence to speak about contemporary issues connected to Israel and Jewish studies. For those of you who aren't familiar with the center, let me tell you a little bit about us. The Schwab Center for Israel and Jewish Studies was established 12 years ago in 2009.
Jeanette, I hate to interrupt you, but I don't see the participants in the room. They may not be hearing what you're saying. Have they been admitted?
Yes.
I apologize to you and to all of you out there. I just wanted to be sure that you are part of the thing. Yeah. My apologies.
It's okay. The Schwab Center for Israel and Jewish Studies was established 12 years ago in 2009 in celebration of Israel's 60th birthday and UNO's 100th anniversary as one of the few Israel and Jewish studies centers in the country. The center is located within the College of Arts and Sciences, and I would like to recognize Dean David Booker, who is with us here tonight. Our mission is to promote the in-depth study of Israel and Jewish studies in all of its many dimensions, from its history, society, and politics to its literature, art, and culture. Our primary goal is to expand knowledge about Israel, Judaism, and the Middle East on the university campus and beyond, while promoting and facilitating collaborative scholarship with institutions in Israel and around the world. We sponsor courses for UNO students. We support faculty research in the academic fields of Israel, Jewish, and Middle East studies. We organize frequent public programs, lectures, discussions, and exhibits. We've hosted visiting academics from Israel, bringing them to our campus. We provide academic and research scholarships to both undergraduate and graduate students from any religion or nationality from a wide array of disciplines. We also provide scholarships for students to study and travel to Israel to experience the country firsthand. This semester, we are engaging in an innovative project of holding an online class with students from UNO, Western Galilee College in Israel, and the Jewish University in Budapest, Hungary. Through our commitment to academic excellence, interdisciplinary teaching and scholarship, and deep community engagement, the Schwab Center for Israel and Jewish Studies seeks to provide a deeper, more nuanced understanding of Israel and Jewish societies, politics, and culture. Now I would like to invite the representative from the Sokolof family, Gary Javits, to say a few words.
Well, thank you very much, Jeanette. And I want to welcome everybody to the Ruth and Phil Sokolof Lecture Series. As Jeanette said, I'm Gary Javich, and my wife, Karen, and our son, Mark, who is in the picture there, are representing the Sokolof family. And Courtney, if you would, for a brief moment, show Karen's picture just for a moment. We're all pleased to be sponsors of this program. It has offered the community and the university a great number of insights into Israel and the world of Jewish studies. As you know, the primary goal of the series is to expand knowledge about Judaism and Israel. It's extremely important because Israel in particular represents a haven for Jews facing anti-Semitism. It is a hatred that continues to pursue Jews in Europe still today. It's a frequent feature on campuses across America, as well as in the form of in the BDS movement. Israel, unfortunately, is a much maligned country, only the size approximately of New Jersey or Rhode Island. On many occasions, it's been falsely called an apartheid state, which is hard to imagine when just last year, before last month's election, the third largest political party in the parliament, or the Knesset, was the Arab Joint List. It's also difficult to label Israel an apartheid state when the Arabs participate in so many facets of the economy and the life in Israel. For example, they've served in the judiciary, one of whom was a Supreme Court justice. There's been a Miss Israel who is Arab, and many Arab students attend university side by side with Israeli students. In any case, despite the seemingly overwhelming challenges, Israel remains a beacon in the world, and that is a principal reason the Schwab Center is so important. And our thanks to Jeanette Gabriel, who is just doing an outstanding job leading the Schwab Center now. At the center, students have an opportunity to learn about the only country in the entire Middle East that permits free speech, freedom of worship, and a free press. Moreover, here at UNO, students can also learn about the many scientific and medical advances developed in Israel that have contributed to making the world a better place. Think cell phones and computers, significant components of which were invented in the land of milk and honey. Let me share just a few medical breakthroughs with you. As a leader in the medical world, Israel's ISRA aid team is among the first on the scene in natural disasters, as they were, for example, in Haiti and Japan. Most recently, Israel sent medical aid to COVID-stricken Uruguay. Their scientists have developed an instant, non-invasive cancer dictation technology, and they have employed artificial intelligence to ramp up speech therapy programs. And I could go on and on. Despite being bombarded, Israeli doctors saved the lives of Syrian soldiers, and indeed just recently saved the life of a Gaza child in complex surgery. There's so many wonderful things happening in America's most valuable ally in the Middle East. And I invite you, the family invites you to partake in the many, many Schwab courses. And with that, I look forward to hearing our presenter. We heard him on yesterday afternoon, and he was very insightful and informative. So, Jeanette.
Thank you very much, Gary. I'm now pleased to introduce our guest presenter tonight, Simon Rabinovitch, Associate Professor in History at Northeastern University in Boston, Massachusetts, where he teaches and writes about different aspects of Jewish, European, Russian, and legal history. Professor Rabinovitch grew up in Toronto, received his BA from McGill in Montreal, and his MA and Ph.D. in history at Brandeis. He was also a doctoral student at the European University in St. Petersburg and a research fellow at the Helsinki Collegium for Advanced Studies. His publications include Jewish Rites, Nationalism and Autonomy in Late Imperial and Revolutionary Russia. He edited Jews and the Diaspora Nationalism, Writings on Jewish Peoplehood in Europe and the United States, and Defining Israel, the Jewish State, Democracy, and the Law. He is currently working on a manuscript called Religious Freedom and the Jews, Collective Rights in Modern States, that compares legal cases in Europe, North Africa, Africa, and Israel, where civil courts have decided on matters of Jewish law and communal identity. Previously, Dr. Rabinovitch was based at Boston University as the Associate Director of the Arts and Sciences Core Curriculum, with an appointment at the Elie Wiesel Center for Jewish Studies. He has also held visiting scholarship positions at Tel Aviv University, the University of Helsinki, and Hebrew College in Boston. Dr. Rabinovitch was a Henry Luce Foundation American Council for Learned Societies Fellow in Religion, Journalism, and International Affairs in 2017-2018. He received the Choice Outstanding Academic title in 2015 for his publication Jewish Rites, National Rites, and additionally in 2015 was on the long list for the Historia Nova Prize for the best book on Russian intellectual and cultural history, and was a National Jewish Book Award finalist in the category of writing based on archival material for Jewish Rites, National Rites. And if all of that wasn't enough, a couple of months ago, he became a U.S. citizen. So without further ado, Rabinovitch for his lecture on What's Jewish About the Jewish State, examining Israel's fierce debate on the nation-state law.
Well, thank you so much, everybody, for having me. Thank you for that really kind introduction, Professor Gabriel. Thank you to the Sokolof family and the Javich family, Dean Booker, and the College of Arts and Sciences at University of Nebraska, Omaha. My only regret, of course, is that I can't be there in person, enjoying time with you. But I'm really so honored to be able to give this this talk and still to be part of your community. And hopefully one day we can do it in person. So today I'm going to talk about the nation state law, Israel's nation state law, its relationship to things Jewish and what it means to be a Jewish state. And that's why actually the programming that the Schwab Center plans and the pedagogy it partakes in is actually perfect for this topic, because this is really about the unity or the questions, the complexities really of the relationship between Israel and Judaism, and a complexity that continues. So I'm going to talk about how this law highlights many of these complexities, and also, like the subtitle suggests, what we can understand from the debates as they've unfolded and they continue to unfold in Israel over the law. It's hard to believe that we're approaching the 3rd anniversary of the passage of Israel's nation-state law. I, for one, feel like July 2018 was just yesterday. It's been a long year and a half or so, but yet at the same time, time seems to be flying by. And it's been a consequential time for Israel, especially politically. Since it was passed in July 2018, Israel has held 4 inconclusive elections. Its prime minister, sitting prime minister, has been indicted and is being tried for corruption. And it has, of course, had to navigate the global pandemic like everybody else. Yet, throughout the past 3 years, and in each electoral campaign, opponents of the law have continually promised to do something about it, though what is a different question altogether. And I think it's fair to say that the nation-state law has continued to exist in the background. It has continued to be unresolved. With everything that's going on, I think that in itself is remarkable. And for many, especially a significant number of parties within the Knesset, it's unfinished business to be taken up at the next opportunity. And again, we can talk about in what ways that might be the case. Furthermore, petitions continue. The Supreme Court held a hearing on its constitutionality, considering 15 petitions in December. And there are regular decisions that address this question of how the law should be applied in legal decisions and in terms of justice. Now, given all of the continued passions over the law within Parliament, among politics, among think tankers and scholars and lawyers and activists, there's always been something of a disconnect between those people, right, that I just mentioned, the politicians, lawyers, scholars, and activists who were the engine for creating this law and are also leading the opposition against it, and the general Jewish Israeli public. Funny enough, I don't think that this is weighing on the minds currently of many Jewish Israelis. It was very controversial when it was passed, and very divisive. And I can talk further about what parts in particular were most controversial there. But most Jewish Israelis have moved on, despite the fact that, like I said, it continues within the political realm, within the intellectual realm, to be fiercely debated. And one of the reasons for that is because of the continued emotional relevance, and we can talk about both the symbolic and practical relevance of the law to non-Jewish Israelis, who constitute anywhere between 20 to 25% of the population. So for those non-Jews, be they Palestinian Muslims or Christians, Druze, Circassians, Bedouins, etc., this law continues to be representative of what they see as their diminished legal status. And for those who are opponents of the law and either supportive of those groups or had always been against the law itself represents a victory of a particular interpretation of the religious and historical meaning of the state on its opponents. And in particular, I think, in a political context, we can see this as representing a victory of the right over the left within the Israeli political context. And for those reasons, the center left, I think, is very concerned to undo or to mitigate it. Now, today I'm going to talk about the law's past, present, and future. And as a historian, I'm always more comfortable in the past, so I will probably spend more of my time talking about the genesis of the law, how it came to be, and why it was passed when it was, than the present and the future. But I do have things to say about that as well, and I have no doubt people will want to talk about it in the question and answer afterwards. And as was alluded to in the title, I think what makes the law continue to have such visceral resonance for both Jews in the diaspora outside of Israel, as well as Jews and non-Jews within Israel, is that it seeks to define in ways that are problematic for some people and unproblematic others what is Jewish about the Jewish state. So I'll begin in the past, and maybe I'll actually begin at the beginning, or at least at the beginning, not at the beginning of the Jewish people, but at the beginning of the state of Israel, to suggest that this is a problem, or at least an open question that has been complex and unresolved since its founding. So if we could just open the first slide in the PowerPoint. Just a little image. So people might recognize both of these images. The one on the right is the seal or the symbol of the state of Israel, and the law which defined a number of aspects of what the symbols of the law of the state were, and the essence and the meaning of the state, also clarified that this particular symbol was the seal of the state. Now, people might recognize that that symbol is a menorah, right? It looks like a Chanukiah, which is a candelabra that is lit on the holiday of Hanukkah, but is the menorah that was a candelabra that was in the temple in Jerusalem. And on the creation of the state, and in the consideration of possible designs for what would be the symbol of the state, this candelabra, right, was chosen to represent the state symbolically. Now, there was only one place that they had an image of what this candelabra would have looked like. And that was the Arch of Titus in Rome, which was a victory arch that was constructed by the Romans to celebrate the victory of the Roman Empire over Judea, the destruction of the temple, and the bringing out of loot and booty from the temple itself. And this was the key piece of victory booty, right? And this was depicted on a relief in a central place in Rome, which tells you, by the way, that it was a really big revolt. But that's a different question altogether. But you have to think about what the complications were, right? The complexities were of choosing as a symbol for the new state a menorah and an image that was taken directly from a victory arch symbolizing the defeat of the Jewish people and the loss of sovereignty in Judea. Now, for those who founded the state, this was seen as a secular symbol of the reconstitution of Jewish sovereignty, right? It was a symbol of the temple, but the temple they weren't thinking about in necessarily religious terms so much as representing sovereignty. But then again, how can one ever disentangle something like a menorah, something like the symbol and the key religious item of the center of Jewish worship, the temple in Jerusalem, from religion? So this is just to say that very early on, there has been this question and this unresolved open issue about the role of religion within Israel, and what do these symbols mean? What is Jewish about them? What is secular about them? Okay, we can drop out of the PowerPoint for now. So now the law itself, just to say a few words about what was in it when it was passed, what it outlined essentially the symbols, what the symbols were of the state, or what the symbols are of the state in terms of the anthem, the flag, that particular seal. It also defined what the meaning of the state was, that is, as a place that is Israel as a place that is uniquely the center of Jewish self-determination. It rooted Israel within Jewish history. And it also reaffirmed a number of commitments that already existed in law to things like citizenship for Jews from throughout the diaspora, a commitment to Jewish settlement on the land in Israel, and several more controversial, well, that was plenty controversial, but other more controversial as well, articles, for example, on language and the days of rest, calendar, essentially what it is that makes the state Jewish. Now, I want to just go back and give a little bit of the lead up, right, to sort of explain what it was, to explain the history and the trajectory and the genesis itself of the law, and what it is that there is such a thing called a basic law defining Israel as the Jewish state of the nation state of the Jewish people. So the first part, that you have to get a handle on, that the first thing to understand is that Israel has no constitution. At the Declaration of Independence in 1948, it specified that a constitutional assembly, a constituent assembly, should be put together and a constitution should be written within 5 months. But the determination of those in government at the time was that to work out those key issues about the relationship, especially between religion and state, in a constitutional document would be too divisive at a time of physical insecurity. And so essentially it was put off. But there was a problem, which was that they needed a guidebook. They needed clear instructions on how to run the government. You know, the terms of the Knesset, the separation of powers within the government, and all the specifics of how one goes about running a government. So instead of creating one big constitution that was passed at one time, in 1950, the Knesset starts to pass constitutional bills ad hoc, right? One at a time. And the idea was that they would create a distinction between regular laws and basic laws, in which the basic laws, even though they were also passed by a simple majority, were designated as having a sort of constitutional authority, right? Relating to the function and the structure of the state. And the idea was that there would be a constitutional committee that would be constantly considering proposals for constitutional laws, constantly drafting them, and passing them as needed. And they would essentially creep towards a constitution, right? And at the point in which there was enough political will to get all of these pieces together and pass them as a constitution and as a whole constitution, then they would do that, right? Guess what? That day has not yet come. It still remains easier to leave certain questions open, right? Easier to leave things ambiguous than to write, collect all of these laws and add more laws and put them together in a formal constitution. So Israel is governed, of course, by all sorts of regular laws, but the way Israel's government governs and it functions is according to these ad hoc laws that have been passed over its existence. These laws, of course, also affect how judges judge and the decisions that they make. Now, like I talked about with the symbol of the menorah and how interpreting what this means, whether this is secular or religious, whether this is a Jewish or a civic state symbol, whether it's about sovereignty or God, and all of these questions remain open, right? Same with the interpretation of each of these constitutional laws. The way these basic laws are interpreted are very much a function of how judges judge. And in the 1990s, there was a shift in how judges started to apply the constitutional laws of the basic laws. This was pretty much a function of the laws coming out of the Knesset itself, because there were two significant laws addressing human rights that were fairly uncontroversial at the time, one on human dignity and one on freedom of occupation. But they were interpreted by justices, especially by the Supreme Court and especially by its president at the time, Aharon Barak, who talked about a constitutional revolution as highlighting and emphasizing the significance of human rights in Israeli law and the need to prioritize individual human rights in the law. The Knesset even further strengthened these stipulations with amendments. In 1994, you can see one of the clearest amendments to both of these laws. If we can go to the second slide. So the basic law on human dignity and liberty already had outlined a number of individual human rights that people had, but it was further amended in 1994 to say fundamental human rights in Israel are founded upon recognition of the value of the human being, the sanctity of human life, and the principle that all persons are free. These rights shall be upheld in the spirit of the principles set forth in the Declaration of the Establishment of the State of Israel. That's good, thank you. So you can see in that language that when judges are put in a position of determining whether the priority of an individual's rights, who is, let's say, not Jewish or sees themselves as a secular Jew, or maybe nothing at all, versus what are perceived to be the collective interests, right, of the state as a whole, justices could come to use these tools in the basic laws to say the individual comes first, right? Of course, the laws themselves circle back to the Declaration of Independence, right, which is very clear that the state is a Jewish state, right? The introduction to these laws refer to the state as a Jewish and democratic state. And so there's a sort of new emphasis on human rights within the law in Israel, and especially the need to balance between, like I said, collective interests and individual human rights. Some people are very happy about this. Others are less so. There starts to be a backlash against what's perceived to be judicial activism. And there are a series of cases in which people feel, especially within the legislature and especially conservatives and think tanks and more conservative legal scholars, that there is a need for a constitution in order to restrain the judiciary, right? That there needs to be greater clarity in the laws so that the judges can't essentially continually prioritize individual rights over the collective interests. The most significant example of this, leading to sort of the biggest wave of constitution writing, was called the Ka'adan case, in which an Arab family had purchased land in a moshav, in a collective community that was entirely Jewish, and were denied the ability to build a home. And this case went all the way to the Supreme Court, and the Supreme Court specifically referred to this law and to this amendment to say that that closed communities were not legal, closed communities that discriminated against any group were unconstitutional, and so were not possible and were not legal. And for many who saw closed communities, kibbutzim, moshavim, as having been the heart of the Zionist enterprise and key to collective preservation, this was an overreach and an overstep of the courts to prioritize these individual rights over the interest of the collective. So in the wake of this case, which comes in 2000, there's a series of, like I said, a flurry of constitution writing. There are several more right-wing think tanks that write constitutions or draft constitutions to submit to this constitutional committee that's always in existence, right? That clarify, in essence, that these collective priorities should come first, right? There are Arab groups and Arab nonprofit groups that write their own drafts that talk about a state for all citizens, that attempt to denationalize the state completely and turn it into an entirely denationalized liberal democracy. And there are also proposals in between that try and balance between these two competing legal interests. Well, it's actually a sort of funny footnote that it's a computer scientist from Bar-Ilan University who was the first to suggest that instead of writing these whole new constitutions, right, to just create a basic law that would clarify the essence of the state, right, that would distill all of those small but substantial items that haven't gone, some of them having been in a basic law, some of them that haven't been in a basic law, to look like what the preamble of a constitution would be. If you were writing a constitution and you had a first 2 pages, let's say, and you had to boil down, this is what the state is about. This is its key symbols. And for the advocates of this law, this is what makes it Jewish, right? What would it be? So this computer scientist at Bar-Ilan, Moshe Koppel, he submits in 2004 a basic law that is just this sort of essence, just the defining what the state is as a Jewish state, what its symbols are, and what are the key items that make it Jewish. In language, in settlement, its symbols, right? And to state outright that it's a product of Jewish self-determination. Now, this sort of sits and doesn't go anywhere until about 2011, when a member of Knesset, Avi Dichter, picks up the idea. Now, he said he is responding to what he perceives to be attacks on the legitimacy of the Jewishness of the state itself, both domestically and internationally. He's also responding to what he perceives to be judicial activism. And he's taking up this mantle, right, of a sort of constitutional warrior, right, to define, to clarify the essence of the state. And between 2011 and 2018, there are numerous versions of this law that are drafted. They all have these ingredients of, again, sort of defining what the state is as a Jewish state, what its symbols are, what they see to be the key elements making it Jewish. And there is variation on this, again, from language to settlement, to the ingathering of the exile, support for Jews in the diaspora, holidays, Sabbath. There's a whole variety of factors that are debated that should go into this particular law. But Dichter was definitely highly motivated by this Ka'adan case. And in fact, he entered one particular article that specifically said that any religious, national, or ethnic group, or language group, I think also, can form a communal settlement for its own purposes. So clearly, one of the purposes of the nation-state law, as Dichter had taken it up, was to reverse this particular issue. Now, there were the president, Reuven Rivlin, the attorney general, and a variety of others had problems with the constitutionality of that particular clause. And so it evolved over time, and we can talk about what it became in its final form. But again, this idea of clarifying what the state is about never really went away. And like I said, I don't think it's actually really ever gone away since 1948. But there were new legal reasons perceived to be necessary to counter what was perceived to be the court's judicial activism. And much of this is still going on. Much of the tension in attempts to clarify constitutionally what the state is about also is about clarifying the powers of the judiciary and the Knesset, as the legislature feels that the judiciary is insufficiently representative of the democracy and of the will of the public when it, let's say, imposes interpretations of the law that elevate individual rights over collective self-interest, what's perceived to be the collective self-interest, that this is insufficiently democratic. So I really became interested in this in 2014 as the issue really heated up. There was a coalition government in which Tzipi Livni was the justice minister. And she also had a personal interest in clarifying the constitutional makeup of the state. Dichter actually began in her offshoot of the Likud party called Kadima. And she, from a legal perspective, she was also a lawyer, or is also a lawyer, had always been interested and felt it was very important to do this legal clarification, ideally to write a constitution, but if that's not possible, then to clarify through this sort of basic law on what the state was about. As justice minister, she appointed a very prominent constitutional scholar whose name was Ruth Gavison to do a sort of assessment of what should go into a law like this, a clarification of the meaning of the state in a basic law if it were to be written. And when this began, it started to get a lot of coverage in English media. And when I was reading it, and I was in Israel for part of this, I was sort of amazed that nobody was really reading the laws themselves. People were arguing about how it was dividing the Israeli public, and what it would change, what the laws, a sort of nation-state law would change, but nobody were reading the drafts of the laws themselves. People didn't have access to the English in terms of what was in the laws. And at the time, I was an editor for an online journal. I was part of the Los Angeles Review of Books. And I sort of used my position there to seek to introduce the public to what the laws actually said. And we published the various drafts of the laws in translation. And then I invited both scholars and people who were involved in the debates over the law to contribute opinions on them. I interviewed people like Livni and Ruth Calderon, who was another person who was involved in one version of the drafting the law. And I sort of stayed out of the analysis of what the law's significance was in order to be able to bring in as many different views as possible. Now, I have to say that when I was doing this, I didn't think that a law would pass. There were many versions that had been proposed, and even though this government, which was a coalition of people, two of the three are still in politics: Netanyahu, Yair Lapid, and Tzipi Livni, as well as others, but those were prominent members of this coalition. Even though it fell over this particular issue, Netanyahu drafted his own version and sought to pass it before Gavison made her recommendations, which led to Livni and Lapid resigning. Ostensibly, the government broke up over this issue, but nobody really believed that that was the case. It seemed to be too trivial, right? And now you could say, okay, the constitutional essence of the state is a very important question. Yes, it is, of course, but so are budgets, right? So is the allocation of ministries and other issues. And I think people sort of accepted that this was something of an excuse, and that that's not really what the dissolution of the government was about. But it didn't go away. And in successive governments, this continues to come up. It continues to be drafted. And to my shock, was actually the final version was passed in 2018. It's funny because two of the contributors to what become this volume, who had contributed to this online forum, were members of Knesset at the time, from very different parties. But one was Benny Begin, who was a member of the Likud, and the other was Yosef Jabarin, who was a member of the Joint List of Arab parties. And when a reading came up in March and the law is resurrected, a new version of the law was resurrected by the Knesset's constitutional constitutional committee, I WhatsApped Yosef Jabarin and I said, "Do you think that this is actually going to pass this time?" And he said, "Yes, I really think so. They're going to pass it." And then I emailed Benny Begin. He's not on WhatsApp to the best, maybe he is, but I emailed Benny Begin and I said, "Yosef says that this is going to pass. Do you think it's going to?" And he said, "That's pure fantasy," which is really interesting because, it was the member of the opposition in the Arab Party who was convinced that they were going to pass at this time because he saw political motivation for it. And it was Begin who was within the government, but was actually opposed to the version that they were promoting, who I think he was holding out hope that the version that had been drafted wouldn't pass because it had been stripped of much of the language that he had promoted that balanced what was democratic about the state and what was Jewish about the state. And so in any event, the reasons why it passed, when it passed in 2018, well, I think that there are three. One was this continued question of judicial restraint, which really was a hobby horse of the right wing in parliament, which again felt that they were not represented by the judiciary, and wanted what was represented by who had become the justice minister, a person by the name of Ayelet Shaked, a tool with which justices could use to legally balance these collective interests and these individual rights. So judicial restraint continues to be an issue. I think also electoral politics, right? One of the features of the law that upset many in the opposition from what was considered centrist parties or the Zionist left was that they would have supported versions of these laws with slightly different language. They would have supported this law if it was explicit about the state also being democratic and also securing the rights of minorities. And there was a sense among many of these people that it had been intentionally stripped of the democratic language in order for them not to support it, because then it could become a cultural wedge issue, right? It was a way of saying, look, those people aren't Zionist. Those people on the left, or those people on the center who they say are on the left, they don't support the idea of Jewish national self-determination, let's say. That if there was a broad and consensus, a broad bill based around some element of consensus, it wouldn't really have political value. And I think that there was certainly Jabarin's perspective was that yes, it was going to pass, because at that time, Netanyahu, this was July, he believed was gearing up for an election in the fall, and he wanted a nice cake. He wanted something to be able to offer the people to say, look what I did that those people opposed. And if they didn't oppose it, then it wouldn't have the same value. The other factor that is really not spoken about, and was certainly never used as a justification, but many of the opponents of the law believe was a significant motivation for it, was annexation. And that if the state were going to annex significant parts of the West Bank or all of the West Bank and shift the demographic reality, then there were those who wanted to ensure that it wouldn't change the character of the state, and that was an underlying motivation as well. Now, when the law was passed, Netanyahu, of course, as did many of the people in his party, called it pivotal. He said, "This is a pivotal moment in the annals of Zionism and the state of Israel. This is our state, the Jewish state. In recent years, there have been some who have attempted to put this in doubt, to undercut the core of our being. Today, we made it law. This is our nation, language, and flag." So he, of course, presented this as a pivotal turning point in history in which the state had finally become theirs, that of the Jews, right? Now, I would probably question to what extent these factors, the Jewishness of the state, were in danger before the law. But it's interesting because it's really both ends of the political spectrum that see the law as very consequential, right?
Yeah.
For those on one end, especially those people who represent people who are not Jewish, the law is consequential because they see it as a disenfranchisement of their rights, and a legalization of a reality that had been left legally ambiguous about their own lack of the rights both to self-determination and, in the case of Arabic, the equality of the Arabic language. They also took very seriously what they perceived to be the danger in the language about the law relating to Jewish settlement and the priority of Jewish settlement. And I have some examples of the, what came out of the final law that we can talk about in a minute. But so on one side, you have opponents who take the significance and the ramifications of the law very seriously, and you have proponents who take the ramifications and the significance of the law very seriously. And in the middle, you have a range of people who think it was probably a good idea, but could have been phrased a little differently, and people who think it was probably a bad idea, but won't necessarily be consequential. Now, I want to talk a little bit about the immediate response to the law, and that it most affected, like I said, citizens of the state who weren't Jewish, right? And I think a lot of this was emotional. There was something about, even though on the ground, and like I said, we can talk about what the specifics of the law say, even though the articles are, like I said, quite ambiguous about what is determined to be Jewish about the state, by leaving out either minority rights or a commitment to equality and democracy, and specifying in the very beginning of the law that Israel was a state exclusively of Jewish self-determination, those who weren't Jewish felt excluded and felt that the state had legalized their second-class status. So I have a few, since I was in Israel at the time, I have a few images to demonstrate this, if we can bring up the PowerPoint. So I think the group that has been most affected by the law on an emotional level have been the Druze, because the Druze are very integrated within the Israeli public and Israeli society. They are conscripted into the military. and are quite patriotic and feel that they have devoted themselves to the success of the state. So following the passage of the law, there were massive demonstrations, and one particular massive demonstration in Tel Aviv by Druze who came from all over Israel to protest the law, painting their faces in Israeli flags, and those multicolored flags are Druze flags, and demonstrating their patriotism really in their sense of betrayal. In fact, I collected newspapers, when I was there over the summer as the law was being passed and at these various protests. And these are images, photos I took from a protest, and this was typical from Yediot Ahronot, the largest daily, or one of, I should say, the largest dailies in Israel, has a picture of a man with his face painted in an Israeli flag and a Druze flag. And it says, "The cry of brothers," right? There was a sense of betrayal among the Druze that they had devoted themselves to this state that had made a determination to constitutionally exclude them. Now, the rest of the Arab public was, I would say, unhappy with the law, but less betrayed. It's funny because you can go to the next slide. This was there was the following week another protest, an Arab Jewish protest, a combined, sorry, just one more slide forward. There was a combined Arab Jewish protest that was much smaller. These are also pictures that I took. The numbers of protests are really hard to get a handle on, but the Druze protest was supposedly anywhere between 50 and 100,000 people, I think, were the numbers. This was, I would say, from having been there, although I heard higher numbers, probably only a few thousand. But one of the realities that represented, the fact that even though the Muslim and Christian Palestinian Arab population of Israel is much larger than the Druze population, but many fewer people came to protest it, was that for those communities, there was less of a sense of betrayal and more a sense that this affirmed something that they already believed to be true, which isn't to say that they didn't want the law repealed or they don't want it changed, but rather, like I said, that it was an affirmation of their existing reality. One of the most controversial responses actually came from a cartoonist. If you can flip the next slide. The law was passed in the wee hours of the morning, I think at about 3:45 a.m. The day before was Herzl Day, and it began with speeches commemorating Herzl Day, with both sides basically saying, Herzl would be proud of this law versus Herzl would roll in his grave. And they finally passed it at about 3:45 in the morning, and the supporters gathered for this famous or infamous selfie. That's Netanyahu in the middle. It's Avi Dichter, the person who started much of this, is the man on the far right. And following the publication of this picture, the Jerusalem Report, a magazine owned by the Jerusalem Post, published this cartoon by a political cartoonist, which you can see borrows from the motifs from Animal Farm. What was even more controversial was that he was fired, that it created such an outcry that he lost his job, and this very much changed his life. And I think that many felt that, to talk about pivotal or to talk about turning point, that also had reflected a change of climate. All right, we can de-PowerPoint. Okay. Now, also, I would say that internationally, what was sort of amazing to see was that the response was almost greater than anything that existed in Israel itself. Jewish organizations around the world that and individuals around the world that saw themselves committed to liberal ideals voiced a range of dissenting and disappointed views. But, and this was, of course, covered in newspapers around the world. I mean, I point out that the New York Times published six op-eds on Israel's nation-state law. That's really amazing. This one tiny constitutional law in, as Mr. Javich pointed out, it's a very tiny country, and there were 6 op-eds written about its significance. So clearly it resonated viscerally, not only in Israel, but around the world. Now, what is its significance, since it's probably time for me to wrap up and open to questions. And I've selected and put in the PowerPoint parts of the law that we can talk about if people want to discuss specific elements of the law. But what do I see as its present and its future? Well, presently, I would say that though many in the Jewish majority don't see the law as being terribly significant on the ground, right, in terms of what it changes in people's rights, the law is interpreted according to people's own historical experiences. So if you were Druze and you believed that you were a part of the state, right, and you felt that this law discriminated against you, right, then you will feel betrayed by it and want it to change or be replaced, right? If you are a Palestinian, Muslim, or Christian citizen who already felt that their language rights were discriminated against, their rights to self-determination were discriminated against, you already felt that you didn't have collective equality within the state, then this would be reaffirming. If you, on the other hand, were someone who was already felt that the Jewish elements of the state were under attack by the judiciary, were under attack by the world, were being attempted to be delegitimized, then you will think of it as an absolutely necessary wall, right, protecting the Jewish elements of the state. Dichter, on his passage, called it the cornerstone after 2,000 years of a lack of sovereignty. It had finally been achieved, right? And if you are, if you are in the Jewish majority, you might have a range of views on it, and it's largely going to be based on your own historical experience. Now, in terms of its present and future, judges are going to judge, right? And this is the thing that I tend to emphasize, that with any laws, they're a subject to interpretation by judges, right? And their relevance is only determined by how they are applied in decisions, right? And even though they have already started to judges have already started to use this as a tool and apply elements of the nation state law to their decisions, right? I would argue that it's not the nation state law that is bringing them to those particular decisions. So most recently, there was a fight in the Haifa suburb of Carmiel, which is a Jewish town, or predominantly Jewish town, in which the Arab population wanted a Arabic language school, or barring an Arabic language school, subsidized transportation to an Arabic language school because they have that legal right to education in Arabic. And the lower court is essentially a magistrate in the decision saying that they didn't have this right, cited the nation state law and the Jewish constitutional right to settlement, right? in stating that this is a predominantly Jewish town, and so these Arab residents don't have any right, constitutionally, to transportation to an Arabic school, or to have an Arabic school, because that would encourage Arab settlement and could change the demographics of the town. Now, in the decision, this was one reason out of, I believe, 7, right? And recently, just in April, this case went to a higher court, and the was appealed, and the decision was upheld. But the court itself said this judge should have left the nation-state law alone, that the nation-state law has nothing to do with this question and was inappropriately applied, but they shouldn't get this funding for this, and this reason, right? And I think that the reality is, now we'll see long-term, right? It takes a long time for decisions to be made. My own sense is that the reality is that these judges will come to the decisions that they want to, regardless of the nation-state law, right? Depending on politics, right? And the same thing could be said by an argument over Hebrew law and the debates that there have been about whether or not to enshrine constitutionally, which was part of this particular law, whether Hebrew law should be considered in judicial decisions or in legislation. I sort of laugh because I've been reading cases now for a while in my own research, and whatever you put in there, there are judges who cite the Talmud and who cite Rashi, and there are judges who cite the UN Human Rights Convention, right? Judges judge according to their own particular political and ideological framework, and will apply whatever law that they see as necessary to get to to their particular end goal. So I think we will only see what the future brings us. And in terms of my own thoughts about what politically will happen to the law, I think that no matter what happens with Israeli politics, it is very unlikely that this law will go away. Repeal, even though it can come through a simple majority, I think repeal, because these constitutional laws do get a gravitas to them about their significance, repeal is very unlikely that there's a majority that comes together to remove it. However, amendment is common, and new bills can be written. That's the nature of an ad hoc constitution, right? And especially with the way that politics are aligning today, and certain taboos on both secular and religious Jewish parties cooperating with Arab parties falling away, I think it's very possible that we get an additional law that, just as this law sought to balance out, I suppose, balance out the particular judicial impetus of the courts by focusing on the collective interests, or what could seem to be the collective interests of the Jewish people. You could have another law that seeks to affirm the rights of minorities and seeks to balance out those interests. And I think it would make sense for me to leave it at that. And like I said, the slides actually have a few specific. I've brought a few specific items within the laws that we could consider.
Well, thank you very much, Simon. You've done a fantastic job of sort of laying out the complexities of the political process in Israel as it interacts with the judiciary. Really some tremendous background there. And it was so interesting to think about this as a backlash against judicial activism around human rights. It was a very interesting point. We do have some questions coming in. The first one is asking if the law defines Judaism in advantageous ways to the Haredi community.
So that is a wonderful question. And I will just say also that we can drop the laws themselves in English and Hebrew if there are any Hebrew speakers in the chat if you want to see the full text. That's my translation. There are other translations out there, but they're not as good. And this is an excellent question, because the Haredim, that is the ultra-Orthodox within Israel, were adamantly opposed to the law. They were opposed to the law because in the same way that the idea of the menorah as a state symbol might be problematic because it's a secularization of these religious symbols. They were opposed to the idea, right, that these secular interpretations of Jewishness, right, as a national identity, and the state as representing national secular identity would be codified in law. And in fact, in the coalition agreement of the government of the Knesset, that would be the 20th Knesset that eventually passed the law with the religious parties, they had put a provision in the coalition agreement that they would have a veto over it. And somebody in the government told me at the time, this guarantees, it's a dead on arrival provision. This guarantees that the nation state law will never pass because the Haredim will never agree to it. But they did. They did for two reasons. One, because there's a question of political capital, right? And it ultimately was an item that they weren't willing to spend political capital on and risk ending their coalition. But the other is that they got significant concessions out of it. So if we could, I could actually, if we could go to the slides. And to flip. So here on this one, so it was the Orthodox parties that had this particular stipulation rewritten to look like it does, right? It says on the connection to the Jewish people that the state shall work to ensure the safety of the Jewish people and of its citizens who are in trouble and in captivity because they're Jewish or due to their citizenship. The state shall act in the diaspora to preserve the bond between the state and the Jewish people. And the state shall act to preserve the cultural, historical, and religious heritage of the Jewish people among the Jews of the diaspora. The way that this was originally written was that it was in all places, right? And the ultra-Orthodox were concerned that this might lead to religious pluralism in Israel itself. If all religious groups of the Jews, all forms of religious heritage, and within this bond between the diaspora and the Jewish people in Israel were to be preserved, there could be legal fights that would argue that, let's say, the American Reform Movement has an equal claim to certain elements of funding religious heritage within Israel. And so this was the key clause that they had changed successfully. I want to get more questions.
Okay, we have a question about the status of the nation state law and whether you think it's possible to have if you think it's possible for the Supreme Court to consider this basic law, or perhaps you might want to answer any basic law as unconstitutional.
Well, the Supreme Court is very aware of the attacks on it. It's very aware that, well, it's aware because there are members of Knesset writing them letters saying that they have no jurisdiction over this issue. But within the public, they know about the attacks on them in terms of constitutional overreach. And so
they're going to act very cautiously. And in the hearings in December, in which there were 15 petitions that were presented to the court, they were sympathetic on some, less so on others, and certain justices expressed that they certainly wouldn't have written the law that way. But they were also extremely cautious and were very clear that there had to be a very high bar for them to strike down a constitutional law. And this is something that's sort of, I mean, maybe strange to us because, you know, in the United States, obviously there's a much bigger process for creating a constitutional law or a constitutional amendment. There it's by simple majority, not different from any other law. Yet by designating these laws, basic laws, it does add a constitutional gravitas. It does come through this sort of constitutional committee. And the Supreme Court was very clear in deciding, and they decided not to strike it down based on these petitions, although there's nothing to prevent future petitions. And it seems clear that certain groups are planning to petition further. They're very clear that it would have to be a very high bar. There would have to be very clear reasons for them striking it down. But they can strike it down. And in fact, you know, the government's lawyers who argued essentially, of course, the position that they should not be even considering a basic law. One of the justices said in response, so if the Knesset passed by a majority a basic law stripping women of the right to vote, we, the Supreme Court, would have no basis for considering its constitutionality. And the response was basically like, wow, that's not going to happen, right? Because, you know, I think it's understood that probably the Supreme Court would step in that particular case. But I don't think that there is anything in this particular law that meets that bar, at least in terms of the perspective of the Supreme Court justices who are there today, which is really quite ironic because the entire impetus of the law, of course, was claiming that the Supreme Court was too judicially activist, right? But they're saying, we're not going to touch this. This isn't going to, now they are considering it. They have said that they are very willing to consider petitions, but essentially that it would have to be a very high bar in order to strike it down. And in these various drafts, you know, the language was written intentionally, ambiguously, right, to be interpreted different ways. So, like I said, the specific criteria, and actually we can bring these, we can maybe bring the PowerPoint back. So if we skip a little bit further, so if you go one more, there we go. So there we go. So in 2011, this was Dichter's original bill. And he said on the right to heritage preservation, again, tried to balance it between a sort of egalitarian collective interest and the collective interest of the Jews. So the first one is about all residents, regardless of religion or nationality, having the right to heritage preservation. The second one is aimed specifically at the Kadan case and says the state may allow a community that includes followers of a single religion or members of a single nation to establish a separate communal settlement. Well, you know, the Supreme Court had already created established law that wasn't okay. And so, you know, a lot of people weighed in and said, you put this on there, it's not going to pass muster. The Supreme Court will interfere in that particular situation. So the net result was, if you go back one, this. The state views the development of Jewish settlement as a national value and shall act to encourage and promote its establishment and foundation. Well, that's a lot more ambiguous, right? I mean, one could say the state supports, you know, Karen Kayemet L'Yisrael, like JNF, you know, financially, and that's their whole mission, right? And they were written in such a way, essentially, that the supporters of the bill could say to the opponents, "What, you don't believe in this?" Right? You know, and to leave enough room to say, "Well, what does that mean, Jewish settlement?" Right?
Can
So
you address the issue of what might be an amendment that the Druze community would put forward?
So that's a really interesting question, because the Druze community is divided. And when, in the wake of the law, many members of the governing coalition were taking, they were not taking seriously center-left Jewish opposition. In fact, I think they thought it was a good thing, because it was, like I said, as a wedge issue, it could be used. They weren't terribly considering taking terribly seriously other Palestinian citizen or Arab Israeli citizens' opposition, because, like I said, I think politically that's also worked for them as a good thing. You know, if they're against it, it has to be good, right? If you're a conservative politician. But they took very seriously the Druze opposition, and they went and met with leaders. But what they were offering essentially was either an amendment or a new bill outlining the rights of the Druze, specifying the rights of the Druze, saying that the Druze have these specific collective rights, essentially to their own communal villages or their own national self-determination, because that was a big issue. It says specifically in the law that only Jews have the right to self-determination. Now, when I went to this protest, I spoke to lots of people, and mostly young people, because those are the kinds of people who speak to me, you know, and there were a lot of families there. Now, they said they weren't interested in that. It was, you know, equality or nothing. Shivayun, that's what everyone was chanting, meaning equality. And they took very seriously the idea that since their patriotism, their devotion to the state was unquestioned, they could represent the minorities. They could protest in a way that others couldn't, that their intentions would always be questioned. And what they wanted was equality. They did not oppose the Jewish nature of the state, but that there was no room in the law for civic equality was really problematic. And they even said to me, you know, we're not like our parents. For our parents, everything was okay. Everything was perfect. Not for us. You know, we all served. Some of these were still serving as professional soldiers. I have to go in every morning and salute the flag. You're telling me that flag isn't mine, right? And that needs to be rectified through a clear indication, not of some special Druze rights, but of inclusion, right? Of the democratic rights that include all the populations, you know, as members of the state. Now, one interesting thing that I was going to mention in terms of an interesting present, right? An interesting result of the present is that despite, you know, the belief at the time that this would inextricably alienate people, right? And I think it did. Like I said, I think there is an emotional, a serious, whatever the practical legal impact ends up being, the emotional significance to those who don't feel included by the law or feel to have been intentionally excluded by the law is real and significant. But you know, the Israel Democracy Institute, which is basically a polling outfit that tries to get the pulse of the public on democratic issues, last year, I think it was a year ago, April 2020, they did an inclusivity poll, basically saying that, asking everybody, Jews and Arabs, you know, how tied do you feel to the state? How much do you feel, I can't remember the exact phrasing, but that your interests lie in the state? In other words, you know, how much skin do you feel you have in this game? and actually, the numbers had skyrocketed. It was something like 92.5% of Jews and 77% of the Arab population felt, it's not saying that they felt included in the state, but they felt that they had an interest in the future of the state. So even sort of divisive issues can actually be an impetus for political participation.
Yeah, and the same point that really comes up there is that this is really still very much in formation. That the sort of outlining rights for different groups or figuring out a path to equity through the interaction between the different political institutions is a process.
Yes, yes, absolutely. And it's one that that I don't know will ever be resolved because of the nature of Israeli society, and the society itself is changing, right? There is a growing alignment within Israeli society of, which is, I think, a product of time, of simple time, an alignment between its Jewish elements and its civic national elements, right? At the beginning of the state, which was a product of a fundamentally secular ideology, there could be this separation, right? And there was this ability to say, well, this is secular, right? But as time goes on, these things merge. I can actually see this in my children's own education. Going to a Jewish day school, it's very similar. State holidays and civic holidays and Jewish religious or cultural holidays, the distinction between them starts to fade over time, and the real challenge of Israel, and I think the ways that this was both a step backwards, but also a potential opening for greater conversation, right, has been to create a path for people who are not Jewish or who don't identify as Jewish, or even many who do identify as Jewish, but let's say the rabbinate doesn't see as Jewish, for them to have a path to inclusion, right, to have a path to feeling in a civic way included in that sort of national project. And I really do think that this law was harmful in that process, and that emotionally there was a great significance to what was outlined in it, and it was interpreted as exclusionary. But the flip side of that is, of course, like I said, people feeling that they want to be included, right? That they want to leverage their politics, right? And their votes, right? That they want to create something else that will balance out this law. And so that is my hope as an optimist, that the efforts that emerge out of the law, and I would say that this is something that is, you can see because of the politics of the day, is actually spanning the ideological divide to attempt to bring people in and more people in. And maybe this is an overly optimistic view, but that hopefully will be the result in trying to create amendments or new laws or new ways for people to be included in the state.
Well, that's a very optimistic interpretation, but I think one that's rooted in legal, sort of very strict legalistic interpretations that give rise to social protest movements for equality. So I think you have a strong historical basis for your optimism. But you've certainly provided a deep, rich context to the nation-state law dialogue, which initially appeared to be sort of very one-dimensional, and yet is rich with all these complexities and nuances of how the legal system functions and how different groups within Israel feel included or excluded from access to the process. So I want to thank you for a wonderful 2021 Sokolof Lecture, and thank everyone for attending. To keep in touch with the Schwab Center activities, please follow our website, and you can see videos of this Sokolof Lecture and past events there. So with that, I will say good night.
Thank you so much.